What's up, everybody? Welcome back to the VSO Gun Channel. It's great to be here with you today because we've got another zinger out of the Supreme Court. I thought that last week was going to be their week. They were going to do it. They were going to go on vacation, and that was going to be it. Well, no. They've come back for week 2, and this specifically deals with the cases out of Illinois dealing with assault weapon bans. And I think many will report this as a loss if you look at it on its face. But I don't think that that's what's going on. There's a lot more here that needs to be unpacked that I think that somebody just passing by may miss. Now, to set the stage, there are many cases out of Illinois challenging the assault weapon bans, and they are in the preliminary stages. The Supreme Court is very wary of touching cases before they have made it to the what they deal rightful stage for their intercession. So if a case is in its preliminary stages, they prefer not to be involved in an interlocutory posture, which means that they've interceded before the courts have rendered their decisions, right? The lower courts. They like to get all of that lined and signed, so to speak, before it comes up to them. They do it that way because they do not want any legal mechanism to undermine their decisions. And I think that that's appropriate. So what happened here is they sent all the Illinois cases back down with some guidance, if you will, or a warning. So we will be hearing from Clarence Thomas and what he has to say about the Illinois assault weapon ban. Boys and girls, it is absolutely beautiful, and you will want to hear this. So we're going to take a quick break to hear a word from our sponsor, and then I will read you what the man wrote and give you the analysis. We have 2 discount codes prepped up for you guys over at Mission First Tactical. One is for the all-day everything stuff, everything from their backpacks to their drinkware to the holsters to even the new translucent magazines that they just came out with. Really like the purple ones, by the way. And then a second code that is for everything that is getting ready to go away, like 50 or 60% off in many cases. So you can find all that information over at the affiliates page, and special thanks to Mission First Tactical for making today's video possible. The state of Illinois enacted a law that makes it a felony to possess what Illinois branded assault weapons, a term defined to include AR-15s. The AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today. 1. Petitioners sought a preliminary injunction against the enforcement of the law, arguing that the law violates their Second Amendment right to keep and bear arms. The Court of Appeals in the 7th Circuit rejected petitioners' request for preliminary injunction, concluding that AR-15 is not protected by the Second Amendment. According to the 7th Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the Second Amendment. This court is rightly wary of taking cases in the interlocutory posture, but I hope that we will consider the important issues presented by these petitioners after the cases reach final judgment. We have never squarely addressed what types of weapons are arms protected by the Second Amendment. To be sure, we explained in the District of Columbia versus Heller case that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. 2. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognizing the historical tradition of prohibiting the carrying of dangerous and unusual weapons. But this minimal guidance is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The 7th Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contouring what little guidance our precedents provide, the 7th Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. The 7th Circuit's contrived non-militaristic limitations on arms protected by the Second Amendment seems unmoored from both text and history.
3.
And even on its own terms, the Seventh Circuit's application of this definition is nonsensical. The AR-15 is a civilian, not military weapon. No army in the world uses a service rifle that is only semi-automatic. In my view, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic rifles used for lawful purposes.
4, 5, 6.
It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. These petitions arise from a preliminary injunction, and the Seventh Circuit stressed that its merits analysis was merely a preliminary look on the subject. But if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the cases reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. Translation from lawyer to regular old English.
These assault weapons are military-grade weapons that don't belong on our streets.
First of all, don't you dare insult me by telling me that my weapon is military grade. My shit is way better than the crap that the military has. Thank you very much. Lowest bidder type stuff. But even if it were a military weapon, the text and tradition of the United States and the Second Amendment says that that is exactly the antithesis of what the Second Amendment means. So that whole argument is bullcrap. And on top of that, you're expressly writing these definitions to capture a classification of rifles that you don't like, but those rifles are the most popular rifles in the United States. And if you wanted to go to, let's just play devil's advocate and go AK-47, you could say that that's the most popular rifle in the world. So to say that you think that these are dangerous and unusual, you might have to convince the court that they are dangerous, but you cannot convince the court that they are unusual. They are absolutely not unusual. And we've already set the thresholds in previous cases, namely the Taser case, of what constitutes a threshold for common use. And it's considerably lower than that. On top of that, what constitutes a bearable arm? I can bear this remote control. I can bear this coffee cup. I can bear a rifle. What does the difference, as far as a bearable arm is concerned, a rifle versus like a short barrel rifle, a short barreled shotgun, a machine gun with a short barrel? You see where we're going here? So what Clarence Thomas has just told the Seventh Circuit is that you are playing a very fun game. And if you do not do your job correctly, and this case ends up back in front of us with the proper impetus for us to grant it certiorari, then we will go into what constitutes a bearable arm. And here's a hint and a warning. You're probably not going to like what the term bearable means, which means carryable, when we go into it, because it's going to include a whole bunch of stuff that you guys have built the last 100 years of gun control on, and it's going to destroy the system that you rely on to take power from the constituency of the United States people. If you were under any illusion as to why they so vehemently attacked this man over the corruption claims and all that sort of stuff, that big snafu that they did about 3 or 4, 5 months ago, it has come home to roost. It is on full display why they did not like this man. They wanted to try to get him out of there. I propose double, triple, and quadruple security on Clarence Thomas every day going forward. They do not like this man because we need this man. This is a little friendly advice. Please, by all means, keep pushing. But if you really wanted to keep the status quo where it is, you would stop pushing, because you end up there with this makeup and y'all are fucked. And I will be here to report on it. Thank you guys very much for tuning in to the VSO Gun Channel. And hopefully we'll see you on another one here pretty soon.